Good morning, everyone. Thank you for joining us today. My name is Erin Kopek, and I'm the Marketing Director for Extra Help, a workforce management resource. Today, you've joined our Workplace Excellence webinar entitled NLRB Turns Workplace Upside Down. And today, we will hear from Sandberg Phoenix and Von Goddard. John Gilbert will be introduced and begin momentarily. Just a few housekeeping things before we get started. This call will last typically about 1 hour. We'll do questions and answers as the presentation continues. We don't have to wait till the end. So if you have questions that come up, please feel free to pose those at the questioning function or your chat box at the bottom of your webinar panel. So let me introduce John Gilbert. He has been practicing law since 1995. John Gilbert brings a wealth of experiences representing some of the largest companies in the United States to Sandberg Phoenix's Edwardsville office. John is a member of the Business and Business Litigation Practice Groups and focuses his practice on labor and employment, commercial, and higher education law, as well as civil rights defense. When working with clients, John dives in headfirst, getting to know all about the client, their business, and the environment in which they operate. He is dedicated to first listening to his clients and working with them collaboratively to achieve their goals. John studied at the University of Illinois and Washington University School of Law. John is a member of the Illinois State, Madison County, and St. Clair County Bar Associations and currently serves as a chairman of hearing boards of the Attorney Registration and Disciplinary Commission. I welcome John. Thank you everyone for attending today, and John, I turn it over to you.
Great, thank you very much, Erin. And I wish I have only been practicing law since 1995. It should have said 1975.
Oh, I apologize.
No, that's okay. It's you know, I'm very pleased that I've lasted 40 years in law practice, and you know, and have had the opportunity really to observe what we're going to be talking about today, which deals with the National Labor Relations Board and what I believe is somewhat of a, not really surprising, but somewhat shocking trend that we're seeing from the NLRB, and which is why I want to get the word out to everybody, HR professionals, businesses that are covered by the National Labor Relations Act, about what the board has been doing lately, and that's the subject matter of the presentation. And the reason I termed it the NLRB Turns Workplaces Upside Down is because what we're going to be talking about this morning deals with a trend that we have seen by the Obama Labor Board toward fulfilling the promise of the administration that organized labor was going to be preferred as a special interest group in this administration, and the NLRB has taken up that cause. And in a series of decisions over the last 4 to 5 years, we're seeing what over the years we have believed were standard workplace policies, standard workplace procedures, and standard workplace practices that have been ruled to be violations of the National Labor Relations Act in quite a shocking way. You know, over the years, most businesses, especially those that are under the National Labor Relations Act or subject to it, have had personnel policies that have been time-tested and have been established for generations, really. And the NLRB in the last several years has launched an attack on those as violations of Section 7 rights under the NLRA, National Labor Relations Act. So let me start with that. And the first slide we have, let's see if I can get it going here. Having some difficulty getting that first slide to come up.
It should work. It might be a bit delayed, but if you just click, it should come over.
Okay.
Are you clicking? There we go.
There we go. Thank you. This is where the story really starts, is that under Section 7 of the National Labor Relations Act, which of course is administered by the National Labor Relations Board, employees have the rights you see here to form, join, or assist labor organizations, to bargain collectively, and to engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. And there are, I mean, I run across this in my practice, that there are clients who don't have unions in the workplace and therefore don't realize that these Section 7 rights also apply to non-union workplaces. These rights apply to any employee in the private sector, because the NLRA does not apply to public employees, but it does apply to employees in the private sector primarily, who meet the tests of the Act, which means your employer has to be involved in interstate commerce. But these rights apply whether there's a union in the workplace or not, and that's become the part of the shock of what the Labor Board has done over the last 4 or 5 years to standard employment policies. Where it all started was, that'll be the next slide here, where it all started was in, well, first though, get the slide up here. Here we go. The NLRB developed a test in a case that's called Lutheran Heritage Village, which is cited in a couple of slides coming up, for invalidating employment policies. The NLRB looks at an employment policy or a rule or a procedure, and the first question the board asks in an unfair labor practice proceeding where this comes up, you know, perhaps an employee was fired or disciplined otherwise for violating a personnel policy, and NLRB file a charge, and then the analysis works this way by an administrative law and ultimately by the board itself. First question asked is, would the rule or policy or practice reasonably tend to chill employees in the exercise of their statutory rights, meaning Section 7? That's the question. The board then asks a series of questions to determine whether the rule or policy or practice does this. And the first question is, does the rule restrict Section 7 activity explicitly? Well, that's rare. You're rarely going to have a policy that says employees cannot form, join, or assist labor organizations or bargain collectively or engage in concerted activities. You know, you never see that. So, but if a rule does do that, of course, it's invalid. The next question the board asks, whoops, sorry. The next question the board asks is, could the rule reasonably be construed to restrict Section 7 activity? And that's where most of the rulings of the board, which have invalidated standard employment policies, has been applied. What the board has done is reach out, and in a number of cases, some of which we're going to talk about in upcoming slides, has concluded that these rules could reasonably be construed by employees to restrict Section 7 activities. And that's where we've run into problems that have been unexpected. The other question they ask is, was the rule adopted in response to Section 7 activity? And again, rarely do you see that. That really means that an employer adopts a rule that prohibits activity because there's activity going on in the workplace that would be covered by Section 7, and that's not often. And then, of course, the other question they ask is, has the rule been used to restrict Section 7 activity. And again, we rarely see that employers who are willfully violating the statute. So where it focuses on is 3A on this slide, whether the rule reasonably can be construed to restrict Section 7 activity, and that's where the board has really found so many of standard employment policies to be invalid under the Act. And so if any of those items that were mentioned in 3 of the previous slide, then the rule is invalid. And as I indicated, most cases are addressed under that test that we just saw in slide 3A. And that case is Lutheran Heritage Village, which is a 2004 labor board case that has been applied over and over and over again the last really 11 years, I guess you could say, but mostly in the second term of President Obama's administration with the current labor board. Now, where it all started was social media policies. We began to see a series of decisions in the last 4 years, 5 years tops, where the board was invalidating social media policies that companies had, which were restricting social media by employees in terms especially of criticizing the company, insulting the company, placing the company in bad light, and in discussing what we would normally think of matters that shouldn't be discussed on social media. So employers began, as a response to the increased use of social media by employees, to have policies. Policies like, make sure that you indicate you're not speaking for the company if you say something. Don't talk about other employees. Don't disparage the company. Things that we would think would be standard common sense policies to protect an employer. And the labor board has absolutely thrown a monkey wrench into that process. When employees, as the slide indicates, when employees post on social media, even if critical of the employer, most of the time, the posting will be protected activity if they discuss anything related to the workplace, and especially if other employees join in with comments or other postings. And that changed everything. That was a sea change in terms of invalidating standard personnel policies. This next slide gives you what I think is, and of course I'm a management attorney, so I'm going to say this, what I think is an outrageous example of what the labor board protects. In this particular case that you see before you, that I chose as an example, the board invalidated a rule requiring employees to identify themselves when posting comments about the employer, and even when the employees used the company logo in a social media posting. Because of the context, the labor board said it was protected activity, and the employee who was terminated for posting what we're going to talk about in a second violated the Act. The employee was reinstated having been terminated, and the termination was held to have been an unfair labor practice. This is what the guy posted, and you'll see it in the second bullet point. Bob, who was his supervisor, the employee supervisor, is such a nasty mother effer, don't know how to talk to people, F his mother and his entire effing family, what a loser, vote yes for the union. And this was posted in the context of complaints about the poster's job. And also there wasn't a union vote actually pending, but it was in the context of complaints about the job. Other employees posted, other employees commented, but the labor board held that this statement that this guy put on Facebook was protected activity and he could not be fired for it. Now, this was, and this is a recent case. This particular case was decided, as we'll see in a second when the slide comes up. This particular case was decided in 2014. Now, the board did say, as you can see in the third bullet point, that statements advocating specific acts of insubordination are not protected. Due to time limitations, I didn't put that in any examples of that in the PowerPoints, but there is a case or two that they decided in 2014 and 2015 that indicates that if the employees are talking on social media about ways to sabotage the workplace, specific ways of sabotaging the workplace, like not filing reports or falsifying information, that is not protected activity. So at least we still have that. But when employees get on social media and they criticize the employer, even in terms, as you see on this slide, the board says that a rule or action that prohibits this or that punishes someone for it can be reasonably construed to restrict protected activity and therefore is invalid. And I can tell you there are worse cases of things that employees have put on social media than you see here about poor Bob. The next slide is sort of well, it talks about confidentiality policies, because social media is not the only area in which the labor board has invalidated policies. Actually, we're going to see several areas besides social media where the board has held what we would have considered standard personnel policies in the past to violate the act, because at least in the board's opinion, these rules could be reasonably construed by employees to restrict Section 7 activity or Section 7 rights. So I've got an example of confidentiality policy taken from a case that was just decided in August of this year, Caesars Entertainment. Here's the policy, and I put it in here because in my opinion, it's a great example of what we would think would be standard acceptable personnel policies that the labor board has shot down. The Caesars had a confidentiality policy, and it's not the best written in the world, but I put it on the slides verbatim. In this one, their policy was all employees were prohibited from disclosing to anyone outside the company, indirectly or directly, any information about the company which has not been shared with the general public. Right now, who would think there's any harm in that? This type of disclosure includes participation in internet chat rooms or message boards. There's the social media aspect of it. Then they went on to say, exceptions to the rule include disclosures which are authorized by the company or required or authorized by law. This information includes but is not limited to. These aren't the exceptions. These are what the policy covered. Company financial data. Now, who would think that that is not a reasonable legal workplace rule? Plans and strategies for development, marketing, and business. Organizational charts, salary structures, policy and procedures manuals, research or analyses, customer or supplier lists or related information. Now remember, this is the rule Caesars had in place. Then they had a process that indicated that the property or corporate law department should be consulted whether there was a question as to whether information was considered confidential and could be discussed or disseminated. And of course, they had a penalty. Any failure to uphold the policy may result in immediate separation of employment. And they had further indicated that all All managerial, supervisory, and selected positions are required to comply. All right, so those of us who have been practicing in this area or who have been involved in HR or personnel administration over the years would not have doubted that this confidentiality policy was reasonable and fair and should be legal. Well, not now, because in the Caesars case, the Labor Board held that this policy was too broad to be legal under the NLRA. And the basis for the ruling was that an employee might reasonably believe that this policy could chill employees in the exercise of their Section 7 rights. And that is because it's too broad. It would include information that employees may legally share with one another and with their unions with regard to wages, hours, and terms and conditions of employment. So that even though some of the categories the Labor Board said were things that could lawfully be restricted from discussion or dissemination, the rule was so broad that it could include, or an employee could reasonably believe that it includes, information that is protected information, if you will. Something that has a relationship to wages, hours, and terms and conditions of employment. So the Labor Board ruled this policy was too broad to be legal under the NLRA. As you might imagine, since these decisions have been turned out almost weekly by the Labor Board, it has really created a problem for policies for employers and how we as management lawyers advise employers about employment policies, personnel policies, HR policies, to be able to pass muster under the NLR, the current Labor Board. In March of 2015, the General Counsel of the National Labor Relations Board issued a memorandum, which is cited here on the slide, Memorandum 15-04, which detail, and I would commend this to all of you to take a look at for policy guidance. What it says, what it does is it lists several types of employment policies that the Labor Board believes are illegal and several examples of employment policies which the Labor Board says will comply with the Act. And the general direction is that to be lawful, policies have to be very specific and limited to information which would not include employment information that could be disseminated between employees and unions. So if you were to look at the policy that we examined from Caesars Entertainment, their confidentiality policy might have been okay had they mentioned that all of those things on the laundry list of items that were not to be disseminated had specifically mentioned that any information related to terms and conditions of employment, wages and hours, or any of the Section 7 type activities that are protected under the Act would be excluded from the policy. And that's what the Labor Board will support, is that you have confidentiality policies that specifically state what information is confidential, and it excludes information which employees have a right under the National Labor Relations Act to share with one another or with a union, which primarily means anything that impacts wages, hours, and terms and conditions of employment. It's still a minefield because cases are decided almost daily by the Labor Board regarding these issues, and the majority of these cases invalidate policies under that very liberal test that they use as to whether or not an employee could reasonably construe the rule or the action to restrict Section 7 activity. So you still need guidance from legal counsel who knows about this stuff to try to develop and implement policies that will pass muster under the Act, or at least with this board. Here's another that was invalidated back in February of 2015. And again, I chose this one because, to me, I've seen similar versions of this with dozens of clients. Standard confidentiality policies that now the Labor Board says are unlawful. This particular one is a confidentiality policy that states that employees acknowledge that in the course of employment they come into possession of certain confidential information that is proprietary to the employer, which includes but is not limited to human resources related information, drug and alcohol screening results, personal bereavement family leave information, insurance and workers' comp information, customer lists, and you can see here the whole laundry list that Battles Transportation had implemented. And you'll even notice it includes fee pricing schedules, methods, processes, or marketing plans that could very easily include trade secrets. Well, in this one, oh, and then of course at the bottom, at the end of it, the employee agrees that he or she will not use the confidential information or divulge it. Well, the Labor Board says, sorry, let's go back to that one, this is too broad. And the hook in this one that led the Labor Board to determine that it was too broad is in the first part of it where it says, including but not limited to human resources related information. The Labor Board determined that that could include information about wages, hours, and terms and conditions of employment, which employees are allowed to talk to each other about, or they're allowed to communicate that information to their union if there's one in the workplace, or to a union if they are members of a union but aren't represented in the workplace. If that had not been in there, it's entirely possible that this policy might have been upheld because of the other specifically described types of information like drug and alcohol screening results, although even that probably an employee would have a right to share with his or her union, so that might have not helped. The leave information, you have to kind of wonder about that one too now under the current Labor Board. Insurance, workers' comp, depending on what it is, it might be protected, might not. Customer lists, that wouldn't be a problem. Investigations by outside agencies. The Labor Board didn't like that because they interpreted this rule to suggest to employees that they couldn't talk about investigations by the National Labor Relations Board. And therefore, that would lead a reasonable employee to interpret this policy as chilling Section 7 rights. And so, could this be edited to comply with the board's decisions? Most likely. But, once again, we have these standard policies that the board is invalidating that no one would have expected. And many of us on the management side take issue with the board's very liberal application of the standard that it uses, that I've repeated many times about, employees, whether or not an employee could reasonably construe the rule to restrict Section 7 activity. Another area where the Labor Board has been active is in access cases. And there are two types of access cases that the board has dealt with. One deals with employees who return to the workplace when their shift is over, when they're no longer working. The other type of access case deals with access by unions to the workplace. That's not what I've addressed in this presentation, because we could do an entire webinar on the law of union access to workplaces. What these cases deal with are access to the workplace by employees who are off duty, if you will. And in the Sodexo case, which was a 2012 case decided by the NLRB, the board held that an off-duty access policy is valid only if it limits access to the interior of a facility. Now, this is access by employees. If it limits access to interior of the facility and is clearly disseminated to the employees and applies to off-duty access for all purposes, not just union activity. So where employers have been tripped up on this one is where employees who are off-duty come back in to maybe sign people up for the United Way, or they'll come in, as many workplaces have employees who come in and they're selling things, whether it's their kids who are selling candy or wrapping paper or whatever the product is. That's what the board is saying, that you can't restrict off-duty access to employees unless you do it for all activities, whether it's union or otherwise. And of course, limited to the interior of the facility, so that if people want to approach employees who are leaving the workplace or coming to the workplace, the board says it's a violation of Section 7 rights to restrict employees from approaching other employees who are leaving the workplace or coming to work when those employees who are approaching employees are off duty. And so the case in the Sodexo case had to deal with, there was an exception to the policy that was at issue in this case, that this dealt with a hospital. Even though Sodexo is a food supplier, one of the parties in the case was a hospital that had an off-duty access policy that said no employee who was off duty could return to the hospital for any reason whatsoever. So that complied with the Sodexo 2012 case. So the board said, well, I'm sorry, the employer had a policy that said there was an exception, that at this hospital, off-duty employees could return to the premises to visit patients or to receive treatment. And the union in that case said that exception violates the law, because the board's Sodexo case had held that access has to be limited or to just the interior of the facility and no access for any purpose at all. And the hospital had an exception to visit patients or receive treatment at the hospital. And the labor board held that that exception was permissible. That exception did not violate the principles of the Sodexo case, and that the hospital could maintain an exception to the no access policy. There are a series of cases dealing with hotels and resorts where employees come back to hotel or resort to visit other employees after their shift, and the labor board has held that unless it's limited to the interior of the facility and applies to all activities, not just labor activities, those policies are valid. But you really have to be careful in drafting a no access policy for off-duty employees to make sure that it complies with the cases that have been decided by the board. The next area that took a lot of people by surprise is the board's decisions regarding email systems. In what is now a famous case called Purple Communications, Inc. that was decided in December of 2014, the Labor Board, in a huge decision, I mean it's probably 60 pages long, talked about the employer's obligations with regard to access to email systems by employees for union-related activity. And in the Purple Communications case, what you see on the slide is basically what the board held. That employee use of email systems for Section 7 protected communications on non-working time must be permitted by employers who allow employees access to email systems. So what that means is, if an employer maintains an email system and employees are allowed access to it for whatever reasons, then the Labor Board has held that the National Labor Relations Act requires that employers allow employees to use the email systems for Section 7 activities on non-working time, and they cannot be barred from doing that. This was a shock, although really not unexpected given the Labor Board's decisions of late, but it was an adjustment that had to be addressed by employers and those of us who advise employers regarding the use of email systems. The prior rule was that you could bar the use of email systems for union activity as long as you barred it for everything else, which was also kind of a pain, because then if somebody wanted to email about a charitable cause, for example, you had to let them email about Section 7 activity. Well, now the Labor Board has said since December of 2014, nearly a year ago, that if you provide an email system and employees have access to it, they have to be allowed access for Section 7 protected communications on non-work time. At least we still have that. Now, at the same time, and in the Purple Communications decision, the Labor Board stated that employers can justify a total ban on non-work email use for email systems that are provided to employees if they can prove special circumstances making a ban necessary to maintain production or discipline. But I can tell you that in that decision, they made it very clear this will be an extremely high hurdle, that the burden will be on the employer to show that it is necessary for the essential operation of the business to have a ban of employees using the email system on non-work time for Section 7 protected activity. It's going to be virtually impossible with this Labor Board, I think, to be able to establish that. But there may be a case or a set of circumstances where an employer could justify it, depending upon the facts of the case. So they left the door open for that. The Labor Board also said in that decision, in the Purple Communications decision, that they were not, specifically not addressing the issue of non-employee access to email systems. What they mean there is it's very similar to access to property for Section 7 purposes by employees and non-employees. And what they're really talking about in that third bullet point is non-employee union access to the email system. They have not yet addressed that, and they specifically said they were not extending this rule to non-employee access of email systems. In the right kind of case, I expect we'll get a decision related to non-employee access of email systems when they get a case where they think that they can, in their view, advance the law. I suspect it'll track the cases that deal with non-employee union access to property of employers, which the rule there is basically that unless there's no other reasonable way to contact employees, then the unions won't be able to use the email system. But that remains to be seen. And with this labor board, it's hard to predict, other than just assuming they're going to rule in favor of organized labor. So that's the status of email system use. And then since Purple Communications, there have been a handful of cases addressing email use in the workplace, but this on non-work time, but Purple Communications set the standard. One of the hopeful, well, you know what, let me talk about that in the next case. Okay, another area where the Labor Board has been extremely active and very insistent is in the area of arbitration rules or arbitration agreements. So, for example, if you have employees either sign an agreement or you have an HR policy that says they have to arbitrate claims, and especially the policy states that employees are precluded from filing joint or class or collective claims in arbitration especially, that's going to be ruled illegal under the National Labor Relations Act. The case that started this is the D.R. Horton case. The original NLRB decision was 2012 and held, as you see here on the slide, that employers violate the act when they require employees to sign agreements or in fact have policies that preclude them from filing joint or class or collective claims in any forum, specifically arbitration or judicial. And the board ruled this way despite the Federal Arbitration Act, which says that the law in the United States favors arbitration. And they also ruled this way in the face of a U.S. Supreme Court decision called AT&T Mobility versus Concepcion, which held that the same type of arbitration agreements that the Labor Board shot down in D.R. Horton were legal in the context of discrimination law. In AT&T Mobility versus Concepcion, the Supreme Court approved arbitration agreements of civil rights claims under Title VII and related statutes, even though they precluded class or collective claims. Well, even with that, the Labor Board said, nope, we think those violate the National Labor Relations Act. So D.R. Horton was the beginning of this in 2012. Well, D.R. Horton was reversed by the Fifth Circuit U.S. Court of Appeals based upon the Concepcion's Supreme Court case endorsement of arbitration, as well as the Federal Arbitration Act preference for arbitration, and other reasons based on the National Labor Relations Act, actually. And the way that, well, let me just say that the U.S. Court of Appeals reviews NLRB decisions. One of the parties has to seek review of an NLRB decision with the Court of Appeals, and generally it's either the District of Columbia Court of Appeals or the Court of Appeals for the venue in which the employer is located. So in this case, D.R. Horton was, I believe, in Texas, so it went to the Fifth Circuit Court of Appeals, and the Fifth Circuit said the NLRB is wrong because the court has approved this in another context, and who's the Labor Board to say that the Supreme Court's view of arbitration agreements is wrong. Well, the Fifth Circuit reversed it, and what do you know? The NLRB continues to file D.R. Horton everywhere but the Fifth Circuit. And in another case called Murphy Oil Soap, an October 2014 case, the NLRB applied D.R. Horton again to invalidate an arbitration agreement that prohibited class action arbitrations, if you will. Well, that was also in the Fifth Circuit, and not surprisingly, less than a month ago, the Fifth Circuit reversed Murphy Oil. Well, not to be judged, the Labor Board, in its latest act of defiance of the Fifth Circuit, said in the Amex Card Services case that was just decided 2 weeks ago that it was still going to follow its decision in D.R. Horton and in Murphy Oil Soap and invalidate these arbitration agreements, which it did for American Express Card Services, everywhere but the Fifth Circuit. So in the rest of the geographical areas of the Court of Appeals, and there are 11 circuits basically that are divided up geographically, the Labor Board is going to continue to follow its decision in D.R. Horton and its decision in Murphy Oil Soap, but just not in the Fifth Circuit. So we'll see how other circuit courts deal with this, but that's kind of our last hope on some of these cases, is that the courts of appeal, when they get them, will reverse the Labor Board on some of these rulings that have so restricted standard personnel and HR policies that apply to employees. The next area that I wanted to address with you is conflict of interest rules. Most employers have these, where employees cannot and are not permitted to engage in activity that creates a conflict of interest with the employer. A standard policy was the one you see here in the case of Echelon Financial Services, which was a case decided by the Labor Board on August 31st, 2015. And I've given you the whole policy because, to me, it looks like a standard conflict policy that I've seen employers have in force for years. And I'm not going to go through the whole thing, but it essentially talks about the reason for the policy, which is the duty of loyalty. And so it asks employees to promote the company's best interest, to not engage in any activity inconsistent with the best interest of the company, or in any way disrupts, undermines, or impairs the relationships with any customer, prospective customer, outside organization, etc. It's a pretty thorough and I think, standard policy. Well, the National Labor Relations Act in the Echelon Financial Services case said that this policy violates the National Labor Relations Act. Why does it do that? Well, they hearkened back to their test of could the rule reasonably be construed to restrict Section 7 activity? And the board said, yes, it can. Now, why is that? Well, because if you go back to the policy, it says that no employee may engage in any conduct or activity that is inconsistent with the company's best interests. Well, in the view of the Labor Board, Section 7 activity, whether it's joining a union, collective bargaining, or other types of concerted activity, might not be in the best interest of the company. In fact, it may be contrary to the best interest of the company, but yet it is still protected activity under Section 7, so this rule therefore violates Section 7, because an employee could reasonably construe this policy to prohibit Section 7 activity that would not be in the best interest of the company in the company's view. The other part of the policy the board said was defective was if it's an activity that can undermine or impair a relationship with a customer or prospective customer or any outside organization, which the board said could include a union. Person could include another employee, entity could mean another person, could mean a union, could mean the labor board, could mean, you know, the plethora of federal and state administrative agencies. So the board said this is too broad. This could be interpreted by an employee reasonably, according to the board, to stifle or interfere with or discourage Section 7 protected activity. So this, again, is a rule that is fairly standard, that I've seen clients, similar rules enacted by clients for many years, and again, many clients, that the labor board now says can't have it because somebody, one of your employees, might reasonably construe this to keep them from exercising their rights under Section 7 of the National Labor Relations Act. Now, there's a case that was decided in June of this year called Remington Lodging. Remington was a resort that had a similar conflict of interest policy, especially related to trying to maintain the image of the lodge, and the court, or excuse me, and the board said, nope, sorry, way too broad, because it was a lot like the EMV payment systems policy. And actually, I got a slide out of order. I want to show you the rest of EMV payment systems policy. It even prohibited outside activity or accepting work in any outside position that interfered with ability to devote full-time and best efforts to the company or raises an actual or potential conflict. And again, the labor board said this was all way too broad and could not be enforced because an employee might reasonably interpret it to be a conflict with Section 7. That General Counsel memorandum that I mentioned to you earlier of March 18th, 2015, which, by the way, you can obtain from the NLRB website, which is nlrb.gov, will give you some additional guidance on what the board believes are legal conflict of interest rules. Now, again, we have not, these cases are still percolating through the courts of appeal. So we don't know for sure how much of what the labor board has done that I've been talking to you about in the last 55 minutes will survive. You know, D.R. Horton is an indication that maybe some of this won't survive, but this is the regulatory environment in which you're operating, so you have to get good advice and be cautious. Now, go back to this one. Those were the issues that I felt we could touch on in an hour. I see we have at least 6 minutes left, and I would obviously love to hear any questions or comments that the participants have.
All right, everyone, if you want to spend the next couple of minutes, if you have any questions, feel free to type those out, and then I can review those. We will give you a couple minutes here before we wrap up.
Great. Thank you, Erin.
All right, looks like there is a question that came in. It says, is this what is driving out policies in companies and going to more guidelines?
Oh, that's a good question because, you know, there has been a trend over time to issue employment policies as guidelines in order to give employers greater flexibility, especially in states that recognize that employment policies can sometimes create a contract. I think that's probably the primary driver of moving from concrete policies to guidelines for managers, but definitely building in more flexibility may help in terms certainly of how the policies are implemented in a way not to violate the Act, but the more flexibility the employer has under this labor board, honestly, I think the more danger an employer may be creating of the labor board concluding that a particular guideline could be reasonably construed by an employee to chill Section 7 activities. I think, unfortunately, we now have to craft more specific guidelines and policies to meet the requirements of this particular labor board. And of course, you know, the next labor board may start reversing all this the way that this labor board reversed several Bush labor board decisions. So that's a good question, but I think the best guidance I could give on that is actually designing more specific policies in the areas in which the labor board has shot down traditional policies.
All right, looks like there's another one. Actually, they don't have any questions, but wanted to thank you for your time and attention on this matter. This information, specifically the examples, are extremely helpful as we move forward with redefining and restructuring our employment guidelines and policy handbook.
Well, thank you very much.
All right, I don't see any more questions, so I'm going to wrap up. I want to thank everyone and our appreciation to the presenter today for joining us this morning. I hope everyone has a good rest of their morning and afternoon and enjoy the Thanksgiving holiday.
Great. Thanks, everyone. Thank you, Aaron.
Thank you.